This is the Sattler Files.
DevRite Homes, when you're looking for attention to detail and a uniquely designed home to suit all your needs. At DevRite Homes, we only build a limited number of homes per year, so we can truly focus on what you want out of a prestige home builder. We've continually won awards for excellence, with a record number of wins last year and the proud winner of the Australian Townhouse Villa of the Year. While we love building homes to suit each client, we pride ourselves on designing homes that take into account the special safety needs of some of our clients. If you have a dream, we can make it come true. Talk to Jay Mangano and find out more about DevRite Homes at www.devrite.com.au.
You need banking services of any type. Secure Force Protective Services run a cash and transit service here in Perth. From as little as $25, why risk your employees travelling to the bank when Secure Force can do it for you? Give us a call at 9440-5011.
You only ever want the best for your family, and no one understands this better than the caring ladies at Marina Perslow and Associates. That's why we offer Australia's leading prepaid funeral plan. It means your family won't be left with the added strain of organising your funeral, and everything will be taken care of, all the little details. Your family will have the support they need with a woman's touch and gentle understanding. So leave them with loving memories and leave the rest to us. Visit marinaperslowfunerals.com.au or phone 9388 1623.
I'm John Hughes. If you want a hassle-free, very enjoyable and happy experience when buying your next vehicle, come to me in Victoria Park. I personally train all my salespeople to be non-pushy, friendly and professional, and we always strive to provide first-class before and after-sales service to all of my customers. So choose your dealer before you choose your car. That's John Hughes in Victoria Park, your car buying destination. DL 6061.
This is the Sattler Files.
Welcome back to the Sattler Files. I'm Jill Clarke. I'm a mortgage broker and talking mortgages today with a guest. I've actually invited Rhiarne Bruce from Thomson Downey Cooper to come in today and have a chat about wills and estates.
Hi, Jill.
How are you going?
Good, thank you.
So usually when someone comes to see me about their mortgage, they're buying or refinancing a property, often they're increasing their debt. Sometimes they have a mortgage joint with the spouse, sometimes with another family member, or even a family member that may have helped them with the deposit. So all of these customers, usually a trigger for me to get them to call you, because I think they should be looking at updating or revising or even making a will if they don't have one. So that's why I thought I'd get you in today and we'll talk about wills. So why would you say it's important that people's wills are updated when they're buying a house or increasing their mortgage?
Yeah, sure. So the mortgage itself isn't specifically the reason why customers need to update their will or look at their estate planning, but usually, as you've indicated, the circumstances surrounding the mortgage. So the customers are buying a new house, perhaps they've just been married or divorced. They're often increasing their mortgage, maybe refinancing, and all of these things are things that need to be considered when looking at the customer's estate planning.
Because there's always something going on, basically. When you're changing your mortgage, whether up, down or sideways, there's always something going on.
Definitely. It's never straightforward, is it? So on one hand, there's the acquisition of the new asset and the customer needs to consider who they want to leave that to. On the flip side of that, they also need to consider how that mortgage will be paid off before they give the asset away. So to make sure that they've got enough, their estate has enough in it so that it can pay off the mortgage and then pass that asset on without the liability attaching to it.
So if there isn't enough, you're talking about perhaps instructions on selling the asset as well.
Yeah. So all of that can be covered in the will, and obviously it will depend on what stage of life, at what time the customer passes away as well, as to how far along the mortgage has been paid off or whether there's enough in the estate to cover the mortgage and that kind of thing. Yeah,
and I guess, if the remaining family members are wanting to stay in the property or not, or if they're already in the property living there as their home or not, or so many things.
Yeah, that's right. There's a lot of things to consider.
Excellent. So sometimes when they come to me, they do already have a will, but often been quite a few years, sometimes many, many years since they last had a look at their will. So is that important that they come and get that reviewed from time to time?
Yeah, so we recommend that people review their wills every 3 to 5 years. Specifically, a review when assets and liabilities change is important, because if there's a specific gift in their will and that asset no longer exists, then that gift will fail. Also, if there's been any change in relationships, children growing up, perhaps you've named someone as your executor who is no longer willing or no longer appropriate. And also, I think every 3 to 5 years, if you just have a general review of your will, it gives you some certainty that your will still reflects your wishes.
So some of those life events that you're talking about, like you said earlier, people may be getting married or divorced. Do those two particular things affect an existing will?
Yeah, absolutely. So a marriage or a divorce will automatically revoke your will.
But in both circumstances?
Yeah, which is, I think, an important thing to remember when you're getting married or divorced.
Yeah. I guess the other thing I see quite a bit of is people who are separated but not yet divorced, and they might be, perhaps one might be buying the other one out, or those sorts of things. So where do they stand if they're still legally married but they're in the process of divvying up their assets?
Yeah, so they're up until the formal divorce, the will is valid. Upon the divorce proceedings being finalised, the will no longer be valid. What can be done though, if the customer wants to tie everything up and is nice and organised, is a new will can be drafted in anticipation of the divorce or or a remarriage. So that will mean that the will stays in force even though the divorce or the marriage has taken place. But it's definitely something that needs to be in the forefront of people's minds when they're looking at their estate planning, and particularly in situations where there's a divorce or a marriage that's either has occurred or is likely to occur.
Yeah, because I think people, don't necessarily realise how long the process takes.
Yeah, no, definitely. Yeah.
Okay, so another thing that I come across quite often is some of my clients do borrow money from family members, or sometimes they even receive a gift, generally from perhaps parents or grandparents, which is maybe, a deposit towards a property. And, as far as banks are concerned, as long as they cover off that it's a gift or a loan, there's no real issue. They will make their decision about whether to lend money, based on that status. But I guess where I get a little worried for some of my generous family members is that they're not always on the title. And I just wonder if there's a way that, or things that they should be discussing if they're giving money or lending money and not on the title.
Yeah, definitely. This is a particular bedbug of mine because I often don't see people until it's too late and there's been a dispute in the family. So I really, really strongly recommend that the person who's giving the gift in this instance speaks to a lawyer and even has that awkward conversation with the person that they're providing the money to, because they really do need something in place to not only protect themselves but also the new homeowners. So it really is necessary for them to have that discussion separately with a lawyer and then also together, so everyone knows that they're on the same page. Everyone has some certainty, and also for the lender, they want some security. They may wish to have some security as well, because like you said, their name might not be on the title, but they have lent a substantial amount of money and would like some security to make sure that comes back to them.
Yeah, and I think the other thing that I sometimes see is, there's other siblings. So maybe mum and dad lend or give, a bit of help with the deposit to one sibling, and then maybe not another because they're just not in a situation to buy. And then down the track, it becomes a bit murky as to was that a gift? Was it part of your inheritance in advance? How does that all wash up? So is that something can be covered in a will?
Yeah, definitely. So I think there's two main documents that kind of cover this situation. The first is putting a loan agreement in place, and it might sound a bit drastic, but it doesn't have to be a long document at all. It can be a very short, straightforward document, just outlining the terms of the arrangement and whether it is a gift or whether there is interest or when do they expect to be paid back by. And then on the flip side of that, if it is a gift, then it's something that can be addressed in the will. If it was part of inheritance, then some kind of forgiveness of debt clause needs to be included in the will so that it's clear to everyone that, hey, you're not receiving the inheritance because you received it as part of this gift for the deposit for your house.
Okay. So then once, because obviously sometimes it's confidential at the time, but once that parent potentially passes away, it's clear in the will that what the intent was, instead of everyone trying to guess what mum and dad were thinking.
Yeah, that's right. Yeah.
Which is, I think, how a lot of these unfortunate disputes come about, don't they?
Definitely.
So besides their will, is there any other sort of legal documents that you recommend that people looking at mortgages should be setting up?
I think it depends on the situation a lot, because you're limited by the bank. There's usually a bank involved still.
Especially if they come to see me.
Yeah. And they're quite particular about what goes on the title and what doesn't, and they like to be the main mortgage on the property. But in terms of the legal documents, other than a will that need to be considered, a loan agreement is definitely something that it would be prudent to put in place. And then from that, there are other documents that the customers can consider, from caveats and equitable mortgages and that kind of thing, which all sound a bit serious, but at the end of the day, it's just about protecting the person who has lent the money out.
Yep. So even where, say, I've got people who've got their own deposit together, I'm just thinking about power of attorney and things like that. Would that be a good thing to get done at the same time as a will, or to have a chat about at the same time as a will?
Yeah, definitely. A power of attorney document is particularly useful when you're in the context of land and property, because it basically provides another person with the authority to sign on your behalf in relation to that property. Obviously, that's always has to be within the person's best interests and that kind of thing. But practically speaking, a power of attorney is a great thing to consider at the time of buying or selling property, because it would allow you, if you were out of the state, unable to sign documents in relation to the sale or purchase of a house, it would allow you to appoint someone else to sign those documents on your behalf, and thereby speeding up the process and making sure everything gets on track.
So my clients that are FIFO, that would probably be very helpful for some of them.
Yeah, definitely. I think FIFO have a lot of issues with lining up banks and signing and witnesses and that kind of thing. So a power of attorney is definitely a useful document for them.
So if someone was FIFO and they were buying property with their spouse who was, say, based in the city, could their spouse be their power of attorney for the signing of those documents?
Yeah, definitely.
But you have to set that up before the mortgage.
Yeah, that's right.
Yeah. So I know that you specialise in wills and estate planning. It's your area of speciality. So, when I am talking to my clients looking at changing their mortgage or increasing their mortgage, I always recommend that they do come and see someone who specialises in your area. But can you just give us an idea why it's better to do that? Because, people say to me sometimes, I can just go to the news agency and get a will kit. What is the benefit of coming to see someone who actually understands this area of law?
So wills, due to their nature, require a lot of certainty, and any ambiguity in a will result in that part of the will being invalid or not enforceable. So if you want your will to accurately reflect your wishes, it really is important to speak to someone about the intricacies of wills. In addition, I think majority of people think that their estate is quite straightforward, but then once you ask a few more questions, things quickly unravel. There was a gift a couple of years ago. There's a ring that they want given to someone in particular. So it really does get quite complex quite quickly, and will kits just aren't thorough enough to provide certainty to the will maker in those instances. In addition, we deal with commercial law as well as wills, which means that we're well equipped to navigate that intersection of wills and business, really. And in this age where more and more people are self-employed or running their own businesses, it really is, they do go hand in hand.
So self-employed people in particular would benefit from coming to see you?
Yeah, really anyone that's involved in a business or has some kind of business structures or entities in place, because we work closely with your accountant or your financial planner to make sure that everything's covered and there's consistency across the board.
And the other thing that I noticed too, blended families. There's a lot of blended families now. So there's step children and step brothers and sisters and step parents, and it's
Definitely.
that some of my clients have step parents on both sides. So there's lots and lots of parents. So someone like that too probably would benefit.
Yeah. I'd hate to see a will kit that's been drawn up in relation to step families and half sisters and that kind of thing. They're what we call Brady Bunch families.
Yeah.
And often they are more complicated because you need to be quite sensitive about who gets what and what side of the family, and what happens if one parent passes away, leaving a remaining parent. Does the deceased parent's children still get catered for? So there's a lot of considerations in those families, and I think it's really important in that instance to speak to someone about it, even just to make sure you've got everything covered in your head and there's nothing else that you've missed or that you need to consider.
And just a question without notice, if someone doesn't have a will at all, what happens when they die to their house?
Yeah, so dying without a will is called dying intestate, and who gets your assets really depends on who you've left behind, and there's quite a formulaic procedure set out in the legislation which states where your assets go. But more often than not, they're split in a certain way, and it's generally not what you would consider or what you would think.
Okay, so you might get you won't, because you won't be there anymore, but your family might get an unpleasant surprise if you die without a will.
Yeah, definitely. In terms of the distribution, it has to go according to the legislation. But then also there's the practicality of not having a will. It is just an extra, it's called getting letters of administration rather than a grant of probate, and it is just that bit of extra work for the family who just don't need it at that time.
Yeah. Okay, so any other tips that you have for us before we go?
I think just generally it's always better to talk to someone before you put your will in place, or before you just, I guess being really preemptive about your legal documents always puts you in a better position than coming to lawyers after there's been a fire.
Yeah, exactly right. Okay, well, thanks very much for coming in and sharing that knowledge with us today.
Thank you for having me.
And if people want to contact you, Rhiarne?
So my name's Rhiarne Bruce, and I'm a solicitor at the firm Thomson Downey Cooper, and I can be contacted on 9325 7755.
Beautiful. And my name's Jill Clarke. I'm a mortgage broker, and I can be contacted on 6364 4945. Thanks very much.
This is the Sattler 5.
DevRite Homes, when you're looking for attention to detail and a uniquely designed home to suit all your needs. At DevRite Homes, we only build a limited number of homes per year, so we can truly focus on what you want out of a prestige home builder. We've continually won awards for excellence, with a record number of wins last year and the proud winner of the Australian Townhouse Villa of the Year. While we love building homes to suit each client, we pride ourselves on designing homes that take into account the special safety needs of some of our clients. If you have a dream, we can make it come true. Talk to Jay Mangano and find out more about DevRite Homes at www.devrite.com.au.
You need banking services of any type. Secure Force Protective Services run a cash and transit service here in Perth. From as little as $25, why risk your employees travelling to the bank when Secure Force can do it for you? Give us a call at 9440-5011.
You only ever want the best for your family, and no one understands this better.
This is the Sattler 5.